This lecture is about trespass to land. Historically, there was strict liability for trespass to land because it helped to protect titles to land. The idea was that, first of all, land was the primary source of wealth in early common law. And when people came onto your land, that was the beginning of them perhaps making some kind of a claim against your land. And to protect landowners against the beginnings of any potential claims, there was strict liability for trespass to land. Now, that was okay for a while, but you run into policy problems. For example, people who do not want to be on the land are not a threat to ownership. For example, a person is riding their horse at common law and they got thrown off the horse and they throw it onto someone's land. They don't even want to be there. They're not a challenge to a person's title. Likewise, a person who is blasting and a rock gets thrown over to someone's land as a result of the blasting. They didn't want to put that rock there. Okay? But those people aren't really any kind of a challenge to a title. And therefore, the rules begin to change, and we now have the rules that have evolved to this. Negligent entry, no cause of action for trespass. Entry caused by an abnormally dangerous activity, no cause of action for trespass. Now let's talk about these two for a minute, because those are exactly what you would expect. For example, if I am driving my car and I negligently hit your car, there's no cause of action for trespass to your car. There's a cause of action for negligence, and you collect the damages for your car as a result of the negligence action. If I'm engaged in an abnormally dangerous activity, and I'm blasting and I blow something onto your land, okay, you don't get a separate cause of action against me for trespass to land. Instead, you sue me because I'm liable for all the harm that's caused if I'm engaged in an ultra-hazardous activity. And you sue on that grounds, not trespass to land, trespass to chattel or land. And so likewise here, negligent entries and entries caused by abnormally dangerous activity, there's no cause of action for trespass to land. However, if there's an intentional entry, there is a cause of action for trespass. The intentional entry doesn't matter if I thought it was my land, or I thought it was government land, I thought it didn't belong to anybody. Doesn't matter what I thought. If I intentionally stepped onto your land, okay, that's a trespass to land, because that's how the beginnings of challenges to title occur. So intentional in the sense that the person has to intend to put themselves there. It doesn't matter what that state of mind was. You can see that from the point of view of the owner of the land. If somebody is stepping onto my land and they secretly think it belongs to somebody else, or they secretly think it belongs to them, I don't care what they secretly think. I don't want them there, and that's where your trespass to land comes from. Now, don't forget the transferred intent. Remember that there are 5 common law torts. These 5 common law torts are trespass to chattel, trespass to land, assault, battery, and conversion. And Prosser, in his first edition, thought that there should be transferred intent among all 5 of those torts. That is to say, if you started out to assault someone, but you ended up trespassing to land, that's okay. The intent to assault is good enough for the intent to trespass to land. So he thought you could transfer intent among all 5 of the common law torts, as well as from person to person. I intended to commit a tort against one person. I committed another common law tort against someone else, intentional tort against someone else. That Prosser thought that all that was okay. But in Prosser's second edition, Prosser changed his mind. He said transferred intent should apply to assault and battery, but not to the other 2. And that is the current restatement position, and is currently Prosser's position. But some jurisdictions and some outlines adopted Prosser's earlier position, so you still see that around, where arguably some jurisdictions may still apply the rule that it's applied, the transferred intent applies to all 5 common law torts. But again, the Prosser's second edition and the restatement says it only applies to assault and battery. Now, this is the history of trespass to land, and now we need to look at the types of invasions. People can certainly invade land by people being there when they weren't supposed to be there. Objects on the land constitute a trespass to land, even very small objects. But be careful here, because when the objects are very small, you might treat them like a gas or like particles. And if they're treated like a gas or particles, now you have a problem. Should they be treated as a nuisance or like trespass? The majority rule now is apparently to treat, you can treat gases and particles like trespass if you want to. This can be important because, for example, there was a case against Reynolds Aluminum where their plant had spewed a lot of particles on someone's land, and the person sued, and the court said that the nuisance statute of limitations, which was only 2 years, would not apply. The trespass to land statute, which was a 6-year statute, would apply, so that this plaintiff could then get more damages against Reynolds Aluminum. Now, of course, the court couldn't say it for that reason, but that it was for that reason. But you can see that courts sometimes are in a position where they can choose between these two. Majority rule is trespass. Next, a type of invasion is refusing to leave or failure to remove objects. If a person refuses to leave after they've been asked to leave, that's a trespass to land and failure to remove objects. There's a case, I think it's in Wyoming, where the municipality made arrangements with the landowner to build a fence along the landowner's border because it bordered on the highway. This was a snowdrift fence so that there wouldn't be as much snow drifting onto the highway and the highways could be used for longer. But the city agreed that the city arrangement was, we'll put the fence up, we'll take it down when the snow season's over. Well, when the snow season was over, the city took down the fence, but they left the pillars in the ground, the concrete pillars. And this person was out using some farming equipment, hit the pillars, and was badly injured. And the court said that was trespass to land because the city did not remove the pillars when they promised that they would. Below the surface of land, that's a mining issue that's not tested on the bar exam. And the airspace above the land, the extent to which you can use it, the usable airspace is the general rule. But again, this is not tested on the bar exam. So that brings us to the point where we now understand the history that you need an intentional entry, and the intent can be intent to enter the land, no matter how mistaken the person was, or any of the transferred intent doctrines, or at least the assault and battery one. But in the jurisdictions where all 5 apply were the ones where you'd want to use here. So we understand how to get a trespass to land. We understand the circumstances under which it might occur. That brings us to who can bring the suit. Only the person with the right to exclusive occupancy of the land can sue. Therefore, the occupying owner can sue. Even if the land is vacant, the owner is constructively viewed as constructively occupying. So that person can sue. Tenant can sue. An adverse possessor can sue. A licensee cannot sue. Finally, brings us to damages. Damages for trespass to land. Trespass to land is an intentional tort, so you can get nominal damages for that. You can get nominal damages for all of the intentional torts. You can get compensatory damages, that is the harm that is out of pocket, sometimes referred to, meaning what do you have to spend out of your pocket to put things back the way they were before this tort happened. That's your out-of-pocket loss, and that's compensatory damages. And it's the harm that is actually and proximately caused. Remember that the actual cause is the but-for, and the proximate cause is really asking the question, at what point in the chain of events that you initiated, at what point does your liability end? Remember that anything that you do right now affects the universe forever. The molecules will not be in the same place they would have been if you hadn't done that throughout for the rest of the universe, forever. And so the question is, where does your liability for this chain of things end? And that's what proximate causation is about. Where does it end? And what I want to point out to you is that in the case of the intentional torts, trespass to land being among them, the proximate causation, where do you end liability, is moved way, way out. Even unforeseeable events, one may be held liable for them for the intentional torts. So there's very little in the way of terminating liability in the case of intentional torts. Of course, they'll terminate at some point, but they terminate much further along the way than for negligence, for example. Finally, punitive damages. if the trespass to land was done with malice, one is entitled to punitive damages. That is about everything. I can't think of anything else you need to know about trespass to land. In fact, this is more than I think you need to know for purposes of the bar exam for trespass to land. And that is the end of this lecture.